Good morning, everyone. We will start in a few minutes. We just want to give everybody time to get signed in. If you could just hold on, hang in there with us for a few minutes. We should be getting started here shortly. Yeah, we've got almost half on, so a few more minutes.
I see that somebody's raising their hand.
Yes.
And
Let's see. I can't
could
do
you
anything.
possibly, whoever's raising their hand, could you put your question in the
in the
Q&A?
Q&A. Yes.
We would appreciate that.
So I don't have any open questions in the Q&A right now.
Okay. Michelle will be monitoring the Q&A. So if someone does have a question at this time,
Right.
just if you could put it there.
And getting there. I'm going to give a couple more minutes.
Okay. Yeah, we'll give it one more minute and then we'll start.
Okay. I guess they're okay.
Sure.
Okay.
I think we have the majority of the folks coming in. So
You ready?
I think we could start. Sure.
Okay. Well, good morning, ladies and gentlemen, and welcome to Optimum Re Insurance presentation of suicide, deconstructing these complex claims. This is brought to you by Monica Clink. My name is Michelle McAllister. I work in the claims department here with Monica, and I am glad that you have all joined us this morning. I hope you enjoyed today's webinar and that it will provide you with some key insight into some of the intricacies, of handling suicide claims. During this presentation, we will be discussing actual case studies that have been through the U.S. court system. We also have a great bonus case study for you at the end for your own consideration of how to adjudicate appropriately. These discussions are intended for educational and informational purposes only and are not intended to make a group decision on any particular claim. All claim decisions are the sole responsibility of the individual direct carriers. Optimum Re is dedicated to improving claims adjudication skills for our client companies as well as our own claims analysts. It is our policy to avoid all antitrust and anti-competitive laws. Please submit any questions that you have in the Q&A section of Zoom. You can submit these throughout the webinar. Monica will provide answers to the questions as time allows at the end of the webinar. If there are any questions that remain unanswered at the end of the webinar, we will respond to those via email to all of the participants. The answers to the questions will be accompanied by a PDF copy of the presentation today, as well as a recording. And the email should arrive in the days following the webinar. If you have any additional questions after the webinar is complete, you may submit those to us at info.us@optimumre.com. That's info.us@optimumre.com. At the end of the webinar, you will be sent a survey. Your feedback is greatly appreciated, and we'd love it if you'd fill out this survey for us. And coming up in July and August, we have 2 additional claims webinars. The first is on July 20th, 2023. That will be hosted by Monica, and it's on the beneficiary experience, unclaimed funds, and interpleader. And on August 8th, 2023, we will also be discussing the always interesting and intriguing accidental death claims, and that one will be hosted by myself, Michelle McAllister. So please join us for those as well. Today, our presenter is Monica Clink, FLMI, FLHC, and FLAU. Monica has been in the insurance claims industry for over some years, she tells me, 27 years, with experience in life, disability income, critical illness, annuity, hospital indemnity claims. She is currently the Vice President of Claims at Optimum Life Reinsurance in Dallas, Texas. She's the Secretary of the ICA, Chair of the Educational Committee, and also participates on the Reinsurance Committee. Busy lady. She's originally from New York and holds a master's in economics from Syracuse University. So, ladies and gentlemen, I present to you Ms. Monica Clink.
Thanks, Michelle. I appreciate that. As Michelle said, today's webinar is suicide, deconstructing these complex claims. Trying to get to the next slide here. Just bear with me. There we go. So we are just going to be discussing today the U.S. market for suicide claims as presented by a life insurance company or reinsurer company. Unfortunately, I do not have a lot of experience in the Canadian market, so I will just be discussing U.S. claims at this time. I will be discussing many legal cases at the end. It is public domain, public record, and I do give citations for these cases, so I have plenty of those to discuss. And I am really just discussing suicide and how it relates to life insurance, but I cannot talk about suicide without putting up some kind of crisis lifeline. I do know it's an epidemic in the United States. So, of course, I won't be addressing all of that part of it. It's just regarding life insurance. But if anybody, if you or anybody you know is in crisis, please reach out to your agencies for help. With that, I will show you the agenda for today. We will go through some definitions regarding suicide. I'll give you some statistics. We'll go through suicide and the life insurance benefit and touch upon the incontestability clause and sane or insane, suicide and accidental death, critical illness, and the conditional receipt. Talk about what happens when you get a suicide claim. What about the suicide investigation? Go through oodles of case studies. And as I said, they are legal cases. I'll touch upon some of the state variations. Of course, I can't list them all, but a couple of the interesting ones. And I'll just do a summary, and then it'll be time for some Q&A. So with that, we'll start with some definitions. So suicide ideation, that is considering or thinking about suicide or even planning it. And we certainly see this kind of documentation in medical records. Be it from a psychiatrist or from the attending physician, it will state if someone does have suicide or homicide ideation. Attempted suicide, that is the non-fatal, self-directed behavior with the intent to die, but the attempt is survived. There may or may not be injury, so there would not be injury in, say, the attempt if there was a drug overdose. Suicide is defined as the death caused by self-directed behavior, and I put the emphasis here, with the intent to die as a result of the self-directed behavior. So really important is the intent. the life insurance company, the direct writing carrier, does have to prove that intent to die. Intent to die, to end one's life, defines suicide for sure. Accidental self-infliction is not suicide. And neither is the gross negligence or misconduct, again, without the intent of taking one's own life. And we will see one of these in the case study later on in the webinar, where there's negligence or misconduct, and it is not suicide. I'm just going to touch upon this really briefly, since we are talking about suicide. Anyone who refuses treatment to prolong their life, it may be seen as intent to commit suicide, but a number of states have legalized and regulated the decisions such that the refusal of treatment is not considered suicide. So of course, Oregon has the Death with Dignity Act. So terminally ill individuals may choose to end their life through the voluntary self-administration of a lethal dose of medication. It has to be self-administered. So the cause of death is actually the underlying terminal illness. So say someone had stage 4 cancer, that would be on the death certificate. It would be stage 4 cancer. It would not be some self-administration of medication. It would not be listed as homicide, suicide, or assisted suicide as the manner of death. It's actually natural. So you may have already seen cases out of Oregon where a terminally ill patient ends their life and you wouldn't know it. We have seen something similar, but it was a foreign claim, of course not from Oregon, but it was a foreign claim. And we had many documents stating that the insured wanted to end their life and they couldn't do it in the United States. So they traveled to a foreign country where they could legally do it. And we certainly had a lot of documentation. But for the most part, if somebody does end their life with self-administration of medication, you probably won't see that. So some statistics. According to the National Institute of Mental Health, suicide was the 12th leading cause of death in the US in 2020. So big caveat there, 2020 was the beginning of the pandemic. I do not have 2021 numbers here. I just have 2020. So please keep that in mind. It was the beginning of the pandemic. It may or may not have influenced these numbers. But in 2020, there were almost twice as many suicides as there were homicides. So how were they distributed? So we had about 46,000 suicides in 2020, majority firearms, and then it goes down to suffocation, poisoning, and other. So firearms for sure is the #1 cause of the suicides. So if we break it out further, we have females on the left-hand side and males on the right-hand side. Females, it's pretty evenly distributed, except for a couple of points here and there, but males by far use firearms when they do die by suicide. So firearms 57.9%, and then the next cause is suffocation. So let's go through the life insurance benefit and suicide. So a typical suicide exclusion could read, if the insured, whether sane or insane, dies by suicide within 2 years from the date of the policy, the liability of the insurer is limited to the amount of premiums paid, less any indebtedness. So let's break this apart. This clause has whether sane or insane. So the insurance company does not have to prove sanity. So it's regardless of sanity, sane or insane, it's if they die by suicide. So the next part, dies by suicide. Well, what is that? You have to really determine if there was the intent to die. Even though the exclusion doesn't have that, we all know that the definition of suicide is the intent to die. Within 2 years from the date of the policy. It is 2 years from the date of the policy, not its reinstatements. That's why the second bullet there, the big bullet, suicide exclusion is independent of the incontestability clause. So if a policy lapses and is then reinstated, and say at reinstatement, the policy, the original policy is 5 years old, the suicide exclusion does not start over. The contestability starts over with that kind of reinstatement, but the suicide exclusion does not run anew from a reinstatement. It runs from the policy, so it is independent. The burden of proof, suicide, is on the insurer. They do have to prove suicide if they are going to rely upon the suicide exclusion. You know, there's a reduction of benefits for sure. It could be a $50,000 life insurance benefit. And if there's suicide involved in the first 2 years, you know, the refund of premium, I don't know, it could be, $1,000. It's a huge reduction in benefit. It is up to the insurer to prove that it was suicide. So the incontestability clause, let's see how this differs. So typical language would read, we cannot contest the initial policy death benefit after it has been enforced during the insurer's lifetime for 2 years from the policy date. The 2-year insured's lifetime, it has to be enforced for 2 years during the lifetime. That's important because if there's a report of a death after the 2 years, but the insured died within the 2 years, we certainly see that, you know, the insured died at 18 months, but it wasn't reported by the beneficiary until month, 30. Outside the 2 years, it's still contestable. That within the insured's lifetime is very important. The incontestability clause also goes on to say what happens when there's a reinstatement. If the policy is reinstated, the statements in the application for reinstatement will be incontestable after the policy has been enforced during the insurer's lifetime for 2 years from the effective date of the reinstatement. So again, when someone reinstates their policy, the incontestability clause is in effect. It is contestable for 2 years from the reinstatement. It has no effect on the suicide exclusion. Let's talk about the sanity. So in most of those definitions for suicide, it does mention sane or insane. So an insurance company doesn't have to prove sanity. Okay. By having sane or insane stated, it avoids the necessity of the insured to have comprehended the moral or legal nature of the act. So the insurance company does not have to prove that. And I do want to make mention here about New York. They adopted the minority rule. And that is if an insane person could not comprehend the act or had no intention, then it couldn't be considered suicide. Okay, so in New York, that proof of sanity is very important if an insurance company is going to rely on the suicide exclusion and pay the refund of premium. Presumption against suicide. So there's a strong presumption of law against suicide. It's just based on the belief that all persons love life and fear death. That's just, common philosophy. Okay, the majority rule is that presumption against suicide is not considered to be evidence. Okay, just because we all believe that there's a presumption against suicide, it's not evidence that someone did not commit suicide. And I'm sorry, I said commit, I apologize, die by suicide. I have to catch myself. The claimant has the burden of proving death resulting from an accident. So an accidental death, there's an increase in benefits that are due. So the claimant has to prove that. With suicide benefit, it's a reduction in benefits, a refund of premium. It is up to the insurer to prove that. So suicide and accidental death. So accidental death rider could define accidental death as resulted directly and independently of all other causes from accidental bodily injury sustained while the rider's in force. The death occurs within 90 days after the injury. And then in a typical accidental death rider, there's going to be a number of exclusions. Here's a typical exclusion. It does not cover suicide or intentional self-inflicted injury while sane or insane. So let's take apart this. Okay, at the end of that clause, you have while sane or insane. I already discussed that's important because then the burden of proof is not on the insurance company to prove sanity. It doesn't matter. Okay, so that's in there. Intentional self-inflicted injury. Okay, intentional self-inflicted injury may not be suicide. So the test for that is not as great as suicide. Suicide is the intent to die. Intentional self-inflicted injury may not have the intent to die, but it could still be a self-inflicted injury. And we do have a case like that coming up in one of the legal cases. So stay tuned for that. Burden of proof of accidental death. I just mentioned it's the claimant to prove accidental death. It is an increase in the benefit beyond the face amount. Okay, how about critical illness? There could be chronic illness as well, but I took it from a critical illness coverage. So again, there's exclusions for critical illness. So and this one that I have, it says we will not pay benefits for a covered condition or procedure resulting from any of the following. There are other ones besides this, but I just grabbed two. You're intentionally causing a self-inflicted injury. You're committing or attempting to commit suicide, whether sane or insane. So it has the sane or insane, which is good. It has self-inflicted injury. The test is not as great as suicide. And then it also has suicide. So this is for critical illness. So critical illness, those are the type of policies that pay for heart attack, stroke, cancer, things like that. So why would this be important? Well, you could have other covered conditions that could have resulted because someone had the intent to die and made the attempt. For instance, someone could have severe burns. Someone could have, set fire, and they could have had severe burns over their body, and some policies cover severe burns. So when adjudicating that kind of claim, you'd have to know, how did that fire start, and see if there was any indication that it was self-inflicted. There could be other cases as well, such as coma, maybe traumatic brain injury. So there are certain cases that we'd want to take a step further and look at, how did it happen? Okay. And again, the burden of proof is on the insurer because it is an exclusion. So suicide and the conditional receipt. Here's an example of language on a conditional receipt, and it's a limitation. If the proposed insured dies by suicide before the company issues a life insurance contract, the liability of the company under this agreement is limited to a return of the initial premium submitted. So why is it important to have this on the receipt? Well, it's before the contract is issued, and you couldn't rely on a suicide exclusion in the policy contract if there's no contract. So this protects the insurance company from paying out full benefit if this person should die by suicide before the contract is placed. Okay, so if I'm reviewing receipts, conditional receipts, any type of conditional receipt attached to a policy here, I do make sure that we see this kind of exclusion there. I think it's very important to have. And again, burden of proof is on the insurer. Okay, so you get a suicide claim. You know the person died by suicide. Now what do? Well, first and foremost, what kind of coverage is there, right? There's life, ADB, critical illness, chronic illness. You have to take in consideration at what time in the policy does it affect coverage. Okay, so life insurance, we have the 2-year exclusion. We talked about that. So if a policy is still in the contestable period, certainly want to take a look at that. ADB and critical illness, those are exclusions for benefit for sure. So we want to take a look at that always. So if there is a claim against ADB and there's reason to believe it's suicide in year 10, we have to take a look at that. Critical illness, in the example that I gave, there was severe burns. Year 10, certainly you have to take a look at that. Was it suicide or an attempted suicide, I should say. So the duration of the policy and the type of the coverage is very important to begin with. The burden of proof. Burden of proof is on the insurer to prove suicide. And I'm going to go into this in a slide or two forward. The death certificate alone is not or may not be sufficient proof. So contestability and suicide provision, they run side by side for a while, right? For the first 2 years, policy could then be reinstated. But for the first 2 years, you have both contestability and suicide. So if a person dies by suicide in the first 2 years, it's reason to do a contestable investigation as well as a suicide investigation. There could be possible misrepresentation. There could be suicide. It's up to the direct carrier to take a look at both of those. Okay. And at the end of the day, the policy could be rescinded. The claim could be denied and the policy rescinded. That means the policy is void due to material misrep. The premium refund check is issued because of the rescission. If a suicide benefit is paid, it's basically saying, yes, the policy is valid. And because it's valid, here's a provision in the policy that provides that the insurance company only pays a refund of premium. Okay, so the same type of check, same amount, but so very different because a rescission voids the policy due to material misrep. The suicide benefits say, yes, the policy is valid. Therefore, we have a provision that we can use to refund the premium. So I mentioned the death certificate. It may or may not be proof of suicide. Okay. On the death certificate, you're not going to see intent. You're not going to see what was the insurer's intent. You're not going to see that. You'll see cause of death, suffocation maybe, and then manner suicide, but you're not going to see the intent. You're not going to see anything about sanity. So New York, you're not going to see anything there. A death certificate could be prima facie evidence of cause of death. So that just means it's, the first impression, that is the cause of death. Okay. It could be. Some courts said maybe not. Okay. So you have to weigh in what jurisdiction would that be. In some jurisdictions, the coroner's verdict is inadmissible because it could be opinion or hearsay. So it could be on the death certificate and the manner of death is not admissible. Coroners or medical examiners may have conducted a limited investigation. And, I have seen that for sure. We'll get, an autopsy report regarding a suicide, and there won't be any GSR tests, gunshot residue. So you won't see any of that. So if it's a gunshot, you won't see where they call it the hands are bagged and they're going to check for gunshot residue. They're not checking for that. It's very important that they do, but sometimes they don't. So suicide investigation, here are some things that might be good to gather. I'm not going to go into the contestability part of it, just suicide. Police report, so that could contain eyewitness accounts of someone, with a gun or someone who's jumping. Autopsy, toxicology. I just mentioned about the autopsy, about the gunshot residue. Toxicology could be, drug overdose, even though, drug overdoses are, there's also other exclusions for drug overdose. Medical record. It's good to get, an idea of what the person was going through. Was there an adverse medical history? Was the person's health just really declining? Was there drug or alcohol abuse? Financial issues or history of suicide attempts? There could be other troubles. So try to get a picture of what this person was going through. And did this person seem hopeless? Interviews with family members and friends, that may or may not help, because some family members, they don't want to address it. They don't want to talk about it. Fully understandable. But if someone does come forward, it might be good to gather that information. Claimant statement. I think this is really important. I think I would highly recommend that a claimant statement have cause and manner of death. if the claimant comes forward and they're completing the claimant statement and there's a place for them to put the cause manner, it's just validation for the insurance company that there may be a meeting of the minds, that the claimant understands how the insured, passed away. I would highly recommend that. The next item here, ballistics. So that would be, of course, in a gunshot wound. Was it possible that the insured fired the gun with the angles and all of that? Or even, just a very basic item is the person is right hand dominant, but yet it was a left-handed shot, something similar to that. Also, you have to prove intent, right? Intent to die. So there might be a suicide note. It's only found in about a third of the cases, not real conclusive sometimes. And keep in mind, it could be planted to cover up homicides. So you might even have to gather some information from a handwriting analyst. Was this really the deceased handwriting? You don't know that. Evidence of psychiatric care. Again, history of suicide attempts, feeling of hopelessness or depression, get a good feel of did this person just see that there's no way out? Symptoms of alcoholism or drug abuse, trouble with significant others or marital status, legal issues. I think we've seen some cases where the question was embezzlement. There was legal issues there. There could have been an intent to die. And of course, recent purchase of a weapon. Furthermore, you could, of course, talk to the family, but I mentioned that there might not be a lot of cooperation. There are expert witnesses, forensic pathologists or medical examiners. Hopefully they do a very thorough job. Medical examiners work with the law enforcement. So maybe they will be gathering more information about, the state of mind of the insured, what was going on in their life. Forensic psychiatrist to reconstruct the deceased background to see if there was intent. And of course, firearms expert. So claims adjudication and disposition. So I talked about what could happen when you're doing a contestable investigation and a suicide benefit review at the same time. So it could be a rescission, you're voiding the policy. Refund check of the premium goes out. Payment of the suicide benefit. Policy terms are being carried out, it's a refund of premium. Or there's no material misrep and suicide is not proven. Policy terms are carried out and it's not the refund of premium, it's whatever other benefits there, face amount or whatever. So there's 3 different options here. I mentioned before that the refund check of a rescission and suicide exclusion are the same amounts, roughly, unless there's interest, okay? But they're very different legally because one voids the policy and one says the policy is in force. If the insurance company is saying, yes, the policy is in force, but it's the refund of premium is due because of the suicide, there might be some opportunity for the claimant to come forward and say it was not suicide, it was accidental. So you would be up against some resistance about accidental death. It would be up to the claimant to prove accidental death. The last bullet here, I really want to stress it. If paying according to the suicide exclusion without performing a contestable investigation, you may be stopped from asserting a defense for misrep if presented with a claimant with a complaint or litigation. So what does that mean? So you get a death certificate and it's within the first 2 years, says the person died, the manner was suicide, and the refund of premium is made without doing a contestable investigation. As I mentioned before, you're carrying out the policy terms. So now if the claimant comes forward and says, no, it was accidental death, you'd be very hard pressed to go back and do an investigation for contestability because you've already carried out the terms of that policy. Talk to some attorneys about this. Some will say that, if you put in a reservation of rights, you might be okay and be able to do an investigation later. Some say, no, it's not going to help you at all. So if there's any reason to do a contestable investigation those first 2 years, barring, I don't know, the cause, no, the manner of death we know is suicide. Sorry, I kind of just went haywire there. You would want to do a contestable investigation so that you would not be stopped later on, just to cover all grounds there. All right, so now I've got a bunch of case studies, so bear with me. I think these are really interesting. I do put the citations. I'm not going to read the actual citation, Smith versus Bankers. I'm just going to read the meat of the case, because that's what I think is really important. But I do leave the citations out here for you, so you can go ahead and take a look at them later. Okay, so this insured died from a single gunshot wound to the head while drinking. Policy contained an exclusion for death from self-destruction while sane or insane. The beneficiary claimed that the insured was so insane due to intoxication that he couldn't realize the act would result in death. So the beneficiary is claiming this based on other Kentucky cases about the insanity part, that you can't claim now, the insurance company can't claim suicide because the insured was insane. The court came back and said that you can't use that insanity exception when the person is voluntarily intoxicated. They stated that one who is intoxicated is held to the same standard of conduct as if he were sober. So beneficiary couldn't claim that. This insured was found dead, apparently of a gunshot wound to the head. The revolver was found in his right hand, and the gunshot wound was to his right temple. So assuming that the person is right hand dominant. The insurer denied due to suicide, and the claimant brought suit. So the plaintiff claims that the suicide exclusion was not applicable because the insured was under the influence of drugs and alcohol at the time of the death and was incapable of forming an intent to die. So it was just like the previous case in a different state. Now, this court rejected that argument altogether because Mississippi follows the majority rule of sane or insane. So they didn't have to even address that. All right, they didn't have to address drugs or alcohol. Mississippi follows the majority of rule. It's died by suicide, sane or insane. So in this case of Rome, the insured was intoxicated again and left the house with a pistol. As he drove off, he said, "Take care of the baby." So it seems like it was just a normal kind of thing, although he was intoxicated and got in his car. He drove less than 250 feet and 2 shots were heard. So to deconstruct what happened with him, there were powder burns, so they did the gunshot residue test. The insured and his wife were separated, but were improving. They were financially in good shape. He had been in good spirits. He was planning on going fishing, but the insurer denied and the claimant brought suit. Okay, so the court found that the deceased shot himself while putting away his pistol and added that accidents are a possibility when alcohol, automobiles, and firearms are mixed. And they also found that there was insufficient motive to overcome the presumption against suicide. They just could not put together a picture that this person had the intent because so many things were improving in his life. They were separated, but getting better. Financially, they were okay. He was just going fishing. Everything seemed to be fine. So in this case, the insurer could not rely on the suicide exemption. This is a Louisiana case, very interesting. The insured died from 6 handgun bullets, 5 in the upper chest and 1 in the left shoulder. The coroner ruled the death as suicide based on the direction of the bullets, an assumption that the deceased was right-hand dominant. The insurer denied benefits due to suicide and the claimant brought suit. So the insurer must establish that there would have been no other explanation but suicide. That is very specific to Louisiana. The exclusion of any other reasonable hypothesis just couldn't fit. This is what they have to prove, that suicide was the only reason. So the court found that there were several people who were interested in the insured being killed. The court opined that it was a bizarre conclusion that the insured would have died by suicide, as he would have had to shoot himself 6 times. And they declared that the claim was covered under the policy. It was not suicide. I can't recall if I've ever had one with so many bullets, but 6 does seem to be quite a few to claim that that was suicide. And that's what the court said. Here's another gunshot wound. The insured was found with gunshot wound to the head. The insured had borrowed gun cleaning equipment 2 days prior, was planning a hunting trip. The insured had been reconciling himself to his wife's recent stroke. He was planning for the future. When he was found, there was blood located through the house. This was similar to the other one. The court held that there was no intent to die by suicide. It was just that he was cleaning his gun and it went off, and unfortunately he died. But they reconstructed what was going on in his life, and they could not find, anything negative that was going on to prove that there was intent to die, because everything seemed to be going okay in his life. Another gunshot wound to the abdomen on this one. And the manner of death was listed as a suicide. So the suicide benefits were paid, and the beneficiary appealed and argued that the death was accidental, but offered no evidence about the manner. All right. So when the beneficiary says it was accidental, it's up to them to prove accidental, but offered nothing, just said it was accidental. Later, they found that the beneficiary had accepted a refund of premium on another policy for the suicide benefit. So the court ruled in favor of the insurer because the beneficiary had already accepted return of premium from another policy within the first 2 years, saying, okay, there's a suicide exclusion, I get the refund of premium. They did that at another insurance company. So they can't now claim that's accidental. And this also was paid the suicide exclusion. I think this is the last gunshot wound. The insured attempted to kill herself, but failed. She convinced a close friend to pull the trigger, which he did, and she died. And the insurance company paid suicide benefits. On appeal, this was found as a matter of law that suicide must be interpreted from the perspective of the insured, and suicide was affirmed. She wanted to die, but this court said she wanted to die. It didn't really matter that a close friend did it. However, Supreme Court reversed that decision. They concluded that suicide can't be interpreted to include death at the hands of another, even though the person had the intention to die. Policy exclusion did not apply, and the beneficiaries were entitled to recover proceeds. As a side note, the person who pulled the trigger was charged with first-degree murder and pled to voluntary manslaughter. Okay, so suicide does have to be at the person's own hand. Earlier in the discussion, I mentioned if it's the Oregon Death by Dignity Act, it's self-administered. So if it's a gunshot, it's a self-inflicted gunshot. Okay, here's a fall case. Life in the ADV. The insured was found dead on the floor of a bathroom in a jail. There were no witnesses, although a guard heard a noise sounding like somebody fell. The coroner ruled that the death was a suicide on the premise that the insured threw himself to the floor from the top of the partition. I don't know how top or how high this partition was. I'm just trying to, visualize how this happened, but I don't know if he climbed up on something. But the coroner says he threw himself down and he died. Trial court found in favor of the beneficiary. Okay, the Court of Appeals found that the accident could be the likely conclusion, and the trial court was not unreasonable in finding for the beneficiary, because where's the intent? You don't have that proof. Could it have been a fall? Could have been a fall. a truly accidental fall. So in that regard, the intent to die had not been proven. So it was made ruled in favor of the beneficiary. Here's another fall. And I say fall, I mean, it could be jump. Jumps, falls, and pushes are difficult. So this was an accidental policy with the exclusion for suicide. The insured was in the hospital recovering from an appendectomy. On the day before discharge, he was found dead on the pavement below his 4th-story hospital room. The screen to the window was unlatched. The window was open. There were bottles that were previously on the windowsill. They had been removed, placed on a table. The company denied benefits based on the suicide exclusion. And on appeal, California District Court of Appeals held that the presumption against suicide had not been rebutted and the verdict was in favor of the beneficiary. Again, the intent to die was not proven, even though there's a window that's opened and the bottles have been removed. They could not prove the intent. One more similar fall, jump, push, however we want to say this. The insured was attending a work-related training session in New York City. He was staying on the 5th floor hotel room. He was found dead on the sidewalk, face down. There were no witnesses. Some people did describe that he had bizarre behavior the previous night. The insured denied for suicide and paid the suicide benefit, and the claimant brought suit. So the Utah Supreme Court held that the burden of proof was on the insurer. That's very typical, of course, and there wasn't enough evidence to overcome the presumption against suicide. The court held that the benefits could not be denied based on the suicide exclusion. You know, yes, the person had bizarre behavior the previous night. That's not enough intent. And, you know, if you're just, you're in a hotel room and you're found dead on the sidewalk, could you have fallen? It might not have been a jump. Could have been a push as well. I mean, jumps, falls, and pushes are very difficult, but here there's no proof that he intended to jump and intended to die. Okay, carbon monoxide inhalation. This insured had attempted suicide and died from carbon monoxide inhalation. The insured denied full benefit on the grounds that the death was a result of attempted suicide. The beneficiary argued, though, that you know, the insured's body was found on the garage floor outside the truck, and the insured had changed his mind about suicide and lacked intent. The court ruled that there was speculation why the decedent died outside the truck, but that could not outweigh the proof that the insurer died from self-inflicted carbon monoxide poisoning. It's hard at that point to get into the head of somebody to say, did he change his mind or was he doing something else? You don't know what happened there. You can't say that he really changed his mind. The court held that proof was there. That he died by self-inflicted carbon monoxide poisoning. Russian roulette. This unfortunately does come up. In this case, the insured died as a result of playing Russian roulette. The Court of Appeals ruled in favor of the insurer to pay the suicide benefit. The decedent knew the gun was loaded and made a conscious decision to shoot. That is, you know, typical of the Russian roulette, that you know that there is at least one bullet in that gun and you shoot. In this case, though, the insured has a recognized suicidal personality profile, that of going through divorce, recent financial loss, changing jobs. There were some other things going on in his life that, you know, that fit the profile. And therefore, they ruled in favor of the insurer, saying, yes, this was suicide. Here's another Russian roulette case. There was an exclusion in this policy, excluded death resulting directly or indirectly from self-inflicted injury or suicide. The insurance company denied, and the claimant brought suit. Now, the court held that the death was a result of a self-inflicted injury, and deliberate suicide did not have to be considered. So that's very important there, to have not just suicide as the exclusion, but self-inflicted injury. And I mentioned that right in the beginning of the presentation, that that's important to have. And this is a case that relied on self-inflicted injury, not suicide. They didn't even have to prove, was their intent to die? There was a clear self-inflicted injury. You have a gun with at least one bullet in there, and you put it to your head and you shoot. That is a self-inflicted injury. In this case, this insurer died of autoerotic asphyxiation. The insurer died on the exclusion for suicide and intentionally self-inflicted injury. So it had both of them. The court found the denial improper. The insured had no intention of dying, and certainly didn't have an intention of injury. It's more of an intention of euphoria, not death. The court went on to say that practitioners of autoerotic asphyxiation expect to survive. They noted that death was a fatal mistake due to risky conduct rather than suicide. So again, this was, I alluded to this case earlier in the presentation, that it is, someone's conduct. It does not necessarily mean it's suicide if there's no intent to die. And in this case, there was no intent to die. Okay, in this case, the insured was found hanged to death. In his pocket was a note instructing that his wife should be contacted, that he does not want an elaborate funeral, and that she should care for the children. The insurer denied the claim for suicide. And at trial, the jury ruled it a homicide. Okay, so let's roll this back. This person in his pocket had a note that he didn't want an elaborate funeral. The wife should be contacted to take care of the children. Could that note have been fabricated? Absolutely. Absolutely, it could. But the court said no. It reversed the finding of the jury and said that there was no evidence of murder, and the jurors cannot, and in quotes, wander off into fields of imagination and suspicion that this was a homicide. It was a suicide. Okay, a drowning here. The insured, fully clothed, wearing a trench coat, was found deceased in a swimming pool. The insurer denied the claims of suicide. The claimant brought suit. Okay. The court found that the insurer had acted arbitrarily and capriciously because the suicide was not the only explanation. So this is Louisiana case. In Louisiana, suicide has got to be the only answer. Only. And in this case, was it the only answer? From what I gave you, from what I understand, no. I mean, you're fully clothed and you're in a pool. Could you have fallen? Yes. Do we know if the person knew how to swim? No, not at this point. I don't know. But those were the type of questions that could have been asked. The suicide was not the only explanation. So the insurance company could not rely on the suicide exclusion. Okay, this was a fire. The insured spread fuel over his house and himself and set fire to the premises and his clothing. He later died of resulting burns. The insured was having marital problems, and on the day he started the fire, he was ordered by the court to stay away from his wife. The insured left 2 suicide notes. The insurer denied, and the claimant brought suit. The court found that this was a clear case of self-destruction, and the notes left behind supported the calculated and clearly intentional acts. And summary judgment was made in favor of the insurer, who relied upon the suicide exclusion and paid the refund of premium. Okay, this one's an overdose. The insured overdosed on drugs during the 2-year suicide exclusion period. Insurer denied due to suicide, and the claimant brought suit. So the insurer claimed that the insured did not die from accidental means since he intended to take the drug. So I'm not going to get into great detail about accidental means and accidental results. That could be for Michelle's presentation on accidental death. But this insured said that they didn't die from accidental means because that's what started the events. Okay, the means was taking the drug. The result was the death. This court disagreed, citing that Illinois does not follow accidental means theory, and the insurer must prove intent. So they said, forget about accidental means. Was their intent to die? And the court said that the direct carrier did not meet its burden of proof of proving intent, and summary judgment was made in favor of the claimant. So again, they did not prove that that insured had the intention to die, even though there was an overdose of drugs. Okay. Oh, this is a conversion one. The insured died by suicide. It's not disputable. This insured died by suicide within 2 years of a converted life insurance policy. The older policy was more than 2 years old. Okay. The insurer paid the suicide exclusion benefits, and the beneficiary brought suit. Okay. The court held that the beneficiary was entitled to recover the full amount of the converted life insurance policy, since the conversion was a continuation of the original contract. The court noted that the converted policy is when the converted policy is identical or substantially similar, then the policies are considered one agreement. And this goes back to one of the original bullets that I put out there, that the suicide exclusion and the incontestability clause are independent, right? In this case, the policy itself was more than 2 years old. Therefore, there's no more suicide exclusion. The incontestability exclusion or incontestability period provision is renewed. Contestability is renewed for 2 years from the date of the conversion. I'm sorry, the conversion. So we have to keep those very separate. The suicide exclusion was done. So the insurance carrier couldn't claim now suicide because the original policy was still in force, even though it was converted. Okay. That was considered one agreement. So we have to be careful about that. If a policy is converted or reinstated, we have to keep those two separate. Okay. All right, Michelle mentioned that there was a bonus case study, like a real life case here. For all you folks that have watched Ozark on Netflix, this was episode 2, season 1. And when I saw this, I was talking to the television about this. Okay, so Marty in Ozark launders money. And in this episode, he had suicide ideation. You know, he had to, I don't know, launder like $8 million. His wife was having an affair. He reached out to his private investigator who was investigating, you know, his wife who was having the affair. So Marty asks Bob, the private investigator, multiple questions about his own life insurance. And specifically, if there's any suspicion that the insured died by suicide, how often would the carrier pay out? Like, he wanted to know, was it 50-50? Was it 80-20? He just wanted to know, when would a life insurance carrier pay it out? So Bob, the private investigator, is speaking for the insurance company, and then he's saying, well, the insured maybe had recent financial problems or unusual behavior, like quitting his job, or found out that his wife had an affair, which Marty just did. And that's all proof that the insurance company would use to try and not pay out, and left it at that. Was Bob right? Bob's half right, because we don't know how long this policy was in force. So Marty doesn't disclose, hey, I've got a policy that's been in force 10 years. He just said, how about this life insurance policy? And Bob just goes on and says all of this. So if Marty had this policy, say for 10 years, and I'm guessing he probably had it longer than 2 years because he had a younger family, Bob's not 100% accurate here, because if it was an older policy, then the insurance company doesn't really have too much to go on if it's more than 2 years old. So that was something that I caught on Ozark. I hope for all you Ozark fans, you can go back and take a look at that. So let's go into some state variations. Again, I'm not going to go through them all, but just a couple that are very interesting. Missouri and Colorado, they exclude suicide for a 1-year period. So if the person dies by suicide in month 18 of the contract, the insurance carrier cannot rely on the suicide exclusion at that time. Okay, it's only that 1-year period. New York, I already mentioned New York, but hey, I'll mention it again here. The exclusion applies only if the insured was sane. So it's the insurer's burden to establish that the insured couldn't appreciate the consequences or didn't have the power to resist. That is a very, very big charge, very big burden of proof that the insurer has to prove. Oklahoma, they've held that the statement on the death certificate, attending physicians, proof of death, or verdict from the coroner are not admissible. Claimant has the burden of proving death was caused by accident, and that is very typical. In Texas, it's not necessary to exclude every other reasonable hypothesis, which is very different from 2 cases that we already talked about from Louisiana, neighboring states, and they're very different. So in Louisiana, the burden rests on the insurer to prove that the insurer died by suicide to the exclusion of every other reasonable hypothesis. Like, that's the only thing that you could lead to. You could only say this person died by suicide. There was no other reasonable explanation. So there's another Louisiana case here. The insured died due to a gunshot wound to the head. There were other stressors in the insured's life, such as death of a friend and death of a father. The court held that there was absence of evidence in support of any other reasonable hypothesis besides suicide. So was there anything else? In this case, no. There were other conditions here that led to intent. Death of a friend, death of this father. There was maybe a feeling of depression, of hopelessness. And the court said, yes, that is suicide. So in summary, suicide is the intentional taking of one's own life. Again, we have to prove intent. It's within the contestable period. Conduct the usual contestable investigation and the suicide investigation. It's important for those both to occur. Death certificate alone is sometimes not enough to prove suicide. One slide mentioned that you can't prove intent on the death certificate and sanity. So be careful of that. Highly recommend that the cause and manner be on the claimant's statement. So when someone is making a claim against a life insurance policy, there could be a meeting of the minds that the claimant understands that the insured died by suicide. And that could be very important to the suicide investigation. Burden of proof, it is the insurance carrier's burden of proof that there was suicide. Please check the state statutes and variations. I gave you a couple here, but certainly not all of them. So it does warrant maybe a look at the statutes before invoking that suicide provision and refunding the premium. And just finally, of course, when there's a refund of premium made during those first 2 years, it could be for rescission that voids the policy. If it's due to payment of the suicide exclusion, it validates the policy. If it validates the policy, your claimant come back and say, wait a minute, it's not suicide, it was accidental death. And then that's a whole another can of worms to open up that, okay, wait, maybe we have to review for accidental death because the beneficiary is resisting it. So not only were you saying that the policy is valid, there might be accidental death to consider as well. So just caution against that. Oh, okay. I think that's about it. So I think we're ready for some questions if we have any, Michelle.
We have a few questions here.
Okay.
So first I saw a Ms. Donnie raise her hand. So if Ms. Donnie, you still have a question, could you please put it in the Q&A for us so that we could try to address it for you? First question we have here is, could you please give us a few examples of suicide by suffocation?
Oh, usually when you see the asphyxiation, that would be suffocation. So we've had hangings. Unfortunately, there has been bags over heads where they're cutting off their windpipe. I've seen some cases where there's someone tapes mouth and nose. So anything that's cutting off that kind of breathing.
Okay, I'm not sure. So if the person who asked this question could just type in the Q&A if you got enough information to your question. It said, can the insurer rely on the death certificate type of suicide to satisfy the burden of proof? You addressed that in your presentation a few times. So if this person did get enough information, and we'll go ahead and move on to the next question. If you did not, please submit your question again to that info.us@optimumre.com, and we will give you more information. So the next question is, once premium refund check is cashed, does that imply acceptance of the reinsurer's decision?
That's a very interesting question, because that was one of the cases that I talked about where one of the courts relied on the cashing of the check from another insurance carrier and say, okay, you've accepted the refund of premium from the other carrier. It's the same situation where it was suicide. So they said it was then suicide. I would recommend that you check with legal counsel about that. Some would say it is acceptance of the benefit. I've heard others say not so much, but I'm not an attorney, so I don't really want to give that kind of advice.
Okay. The next question says, if policy was issued in another state than New York, but death happened in New York, does the suit happen in New York and follow that strong burden of proof, or in the state the client lived permanently?
Okay, so say this again. It was issued in New York?
The policy was issued in a state other than
Not
New York.
Not New York. Okay.
But the death occurred in New York. Does the suit happen in New York and follow that strong burden of proof, or in the state the client lived permanently? So it's the jurisdiction.
Okay. Well, I do have New York. I have a citation of New York. Let me just take a second here. It doesn't mention the citation that I have. The suicide as a defense doesn't specifically state. It states that this policy is issued in New York, have to have the exclusion of benefits, within the first 2 years based on suicide. So that's very typical, but I'm not seeing where it has to, which governs, what jurisdiction, when the person dies, what jurisdiction do you use? I'm not seeing that in New York. I'd have to take a look at that and see if I can gather some more information.
Okay. The next question is, how does the place where the insured died factor into a claim, if at all?
Does that mean the state?
Yes, I don't know if this person would want to give us some more information in the Q&A now. I'll look to see. Let's see. It's other country.
Other country?
Mm-hmm.
Ooh. We do have quite a few foreign deaths for sure that we see. And I'm just trying to, go through all the claims in my head right now. I very rarely would see suicide claim on a foreign claim. I'd rather, I can't recall seeing very many suicide claims when they're foreign, other than the one that I alluded to, which wasn't really suicide. It was, like assisted suicide in another country, but that's not truly suicide. I generally don't see that. And yeah, that would be very difficult to investigate, because that's, if you're looking for suicide exclusion within the first 2 years, so it is contestable, the policy is contestable, and it's a foreign claim. That's like the trifecta right there. very difficult to investigate. That's, but I've never had one.
Privacy contacts have been updated. You can take a review the updated items on your screen.
All right.
That's okay. Are you ready?
Yes, sorry.
Okay, it's okay. The next question we have are some direct companies may offer to backdate a policy, save age up to 12 months. As a reinsurance company, what is your opinion, including concerns when saving age to a year in reference to the 2-year suicide and contestability period?
No, I was going to bring one of those cases in to the discussion, and I did not, but I did see one. Let me see. I have a site. Look at that. I found one real quick. Let's see. Plaintiff. Let me see if I can. Sorry, I'm going to do this real quickly here. It's not a very long discussion. Let's see. The plaintiff claimed that the 2-year period has expired prior to the insured's death because the policy had been backdated. This is this type of situation, correct, Michelle? And
Yes.
to include the period when the insured had a temporary insurance application. No, that's temporary insurance agreement. It does show backdated, but that's not a true backdated issue. Yeah, so you really have to rely on the language in the policy, right? So very rarely would the policy language run, like an exclusion or provision, run from the date the application signed. It's issue date, policy date. In my, in my career, I generally just go back to the language and see which date rules there. And I realize there could be backdated policies there, but I have to go back to the policy because if it's challenged in court, that's what I have to rely on.
Okay. I think the person that had the question about the suicide burden of proof with the death certificate got enough information.
Okay.
Okay, so next
Good,
question
good.
we have is any drowning cases reviewed? Seems like they would be hard to prove.
Right. So one of the cases that I did review was someone found drowned in a pool. That was the one where the person was wearing a trench coat and just found in the pool. And yeah, that was difficult because to say it was suicide, because where's the intent? Was there something else that could have happened? Could the person have fallen? And if there's no intent to die, and if it could be an accident, and if it's not witnessed, absolutely, it's very difficult. We've had some other, real cases other than these litigated cases that I brought up. And, this was just like stock litigation. This was not, these are the cases that I could find. We've had some cases like that. And yeah, sometimes they don't rule it a suicide because it's difficult to prove. You don't know if someone fell. And if someone could have fallen, there's reason to pay. Michelle, you're muted.
I'm sorry,
That's
I'm trying
okay.
to click. The next question I have is, what if the insurer dies in another state who had different laws? So again, here we have jurisdiction.
Yep. I've got to take a look at that. I'm not quite sure. And as I said, I'm not an attorney, so I'd have to take a look at that.
Okay.
And it could be that it even depends on the states. So I don't know.
Okay. Next question. What verbiage would you recommend using in the claimant statement to indicate the suicide was intentional?
Well, I've seen claimant statements where it's just asking for the cause or manner of death. Cause is different than manner, but for the general population, they would say, suicide is the cause of death, but it's the manner. Generally, I would say just ask them to state it. Not necessarily, they don't have to go into great detail that it was intentional. I realize that people that complete claimant statements, beneficiary statements, however whatever they're called, they're mourning, they're having a difficult time. I wouldn't want to get into a whole explanation of it. You're just asking to ask to have that for your records, but I don't think you have to state that, state if it was intentional, because suicide by our definition is intentional.
Yeah. Okay. I believe this is just a comment. It says the Netherlands has assisted suicide, just
Oh,
thinking for those foreign suicide
okay.
claims. The next question I have is, what if beneficiary comes back and claims death was a homicide? Is the burden of proof on them or the insurer to prove homicide?
Okay, so we're saying maybe the policy was denied for suicide,
Yeah,
and they're saying no, it was homicide.
mhm.
So, well, I mean, they may have to come back with a burden of proof on that, just like one of those cases where the person said no, it was accidental and provided no other information. If the company has already said it's suicide, they may have to rely on what the beneficiary can prove. Of course, try to do their own investigation, but the beneficiary might have something else. I would say if it's benefits that are going to be paid and they've already been denied, I'd say it's the beneficiary that has to come forward and try to prove that.
Okay.
That's a whole other discussion as well, because we've known beneficiaries to have played a role in the death of the insured. So that's a whole kind of different discussion. This probably is, maybe some kind of instance where the beneficiary had nothing to do with it, but maybe I've seen or heard about hangings that are a cover-up for homicide, and they'd have to, review that a little bit further.
Yeah. Okay. The next question is about jurisdiction again, so I will address that.
Yeah.
Again, when we send out the answers to some of the questions via the email, we will address the next question about which state laws are in effect,
Okay.
if the person
Yep.
dies outside.
Yep.
And I got a couple of excellent presentations and much appreciated and great, and thank you. So, well, thank you, Monica. It was a
Okay, sure.
great presentation. And we have a couple of more minutes if anybody has any questions.
Yeah.
If not, we'll go ahead and conclude. I don't see anything coming through. So I'll just remind you that all of the participants today will receive an email that will have a recording of this presentation, a PDF copy of the presentation, and an answer to some of those questions where Monica needed to get some more information. Oh, sorry.
There's a
We have
question?
another question.
Sure,
Again,
sure,
another question
sure.
is, what about suicide by police? Good question.
Well, that is very similar to a case that I discussed, where the person wanted to die and had an attempted suicide, survived, and then had a friend do it. Suicide, most courts are going to say suicide has to be at your own hands. It can't be at the hands of someone else. So if you apply that kind of logic, I would say that it is not suicide if someone else is doing it. Similar to, like, it has to be it's self-administered. If someone is taking a medication, it's got to be self-administered at your own hands. If it's a gunshot wound, it's your own gunshot.
Understand? Okay. And then we have, does North Dakota have a 1-year suicide provision as well?
Let me see.
Mhm.
Let's see if I can find it real quick, since we have a minute. From the information that I have real quick, I do not see the 1 year. I do see that it's the presumption that death is not the result of a suicide, which is the majority rule. And they have to prove by preponderance of the evidence that the death was a result of a suicide. That's just the information that I have at my fingertips on such short notice. I don't see that it's a 1-year exclusion, but I'm not sure. This is all the information I have at this time.
Okay. And no more questions. A few more comments. It's excellent, very informative. Always learn something new, and thank you. And it was a great presentation, and they are looking forward to the next session. So
Okay.
again, we'll go ahead and end this session and remind you that you will get a recording and a PDF copy of the slides here, as well as responses to those questions where Monica needs to do a little bit more research. Please complete the survey that you'll receive. It will come right after this webinar ends. And we appreciate your feedback. At all times, it helps us to improve and make this better for you, because we enjoy presenting the information, and we like that you enjoy receiving. So thank you for your time and participation today, and we will get those emails out to you soon.
Thank you, everybody. Thank you.
Thank
Until next
you.
time. Okay. Bye-bye.
Bye.